Well, friends, two more points of light amidst the Trump-induced darkness. New York Attorney General Leticia James and Manhattan District Attorney Alvin Bragg, each of whom, when Donald Trump's lawyers demanded that they dismiss Trump's cases, both civil and criminal, James and Bragg said not only no, but oh, hell no. Okay, that's my characterization regarding how they said no, but they said no. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, as we continue to acknowledge the gathering Trump darkness, we will keep looking for and supporting and feeding the points of light. So let's take on two quick legal developments. One involving Donald Trump's civil case, the case that was brought, that was pursued by New York Attorney General Leticia James, and the other Donald Trump's criminal case, prosecuted by Manhattan District Attorney Alvin Bragg and his prosecutors. This headline in Forbes: New York AG Leticia James rejects Trump's request to drop civil fraud lawsuit. And that article begins, New York Attorney General Leticia James refused to drop her office's civil fraud lawsuit against President-elect Donald Trump, arguing Tuesday Trump isn't immune from civil lawsuits, even though the federal criminal cases against him were dropped after he was elected. James' office said Tuesday in a press release that the judgment against Trump, in which he was ordered to pay $454 million plus interest, does not impact any conduct that Trump might undertake as president. And his inauguration is irrelevant to the 14 other defendants found liable in our case. James' office made the statement in response to a request last month from Trump's lawyer, John Sauer, to drop the lawsuit for the greater good of the country, citing the dismissal of his federal election interference and classified documents cases per the Justice Department's long-standing policy of declining to prosecute sitting presidents. Friends, talk about the shamelessness of Donald Trump's mouthpieces, saying that even though after a full, fair, and free trial, Donald Trump was found liable of engaging in long-term systemic business fraud and was ordered to pay $454 million plus interest for that fraud he perpetrated, and yet Donald Trump's mouthpiece says the case should be dismissed for the greater good of the country. There are no words for that one. Let's turn to Donald Trump's criminal case, the case in which he was convicted by a jury of his peers unanimously of 34 felony crimes. That's the case that was prosecuted by District Attorney Alvin Bragg and his team of prosecutors. Here's the headline from USA Today. President-elect immunity does not exist. New York prosecutors defend Trump convictions. And that article reads, Manhattan prosecutors urged a New York criminal court to keep President-elect Donald Trump's hush money case alive, even if sentencing is pushed out past Trump's next presidential term. Quote, President-elect immunity does not exist. Lawyers from Manhattan District Attorney Alvin Bragg's office wrote in the court filing made public Tuesday. Quote, at most, Trump should receive temporary accommodations during his presidency to prevent his criminal case from meaningfully interfering with his official decision-making. Trump was convicted May 30th on 34 felony counts of falsifying business records to cover up a hush money payment to porn star Stormy Daniels just before and to cheat in the 2016 presidential election. He was originally scheduled for sentencing in July, but the sentencing date was repeatedly pushed back. Trump is now arguing that sentencing should be canceled and the case should be dismissed as a result of his election. Quote, burdening the presidency with a biased prosecution by a local prosecutor would not only be unconstitutional, but also unbearably undemocratic to the people of this country who chose President Trump as their leader. Close quote. Trump's legal team wrote in a motion calling for the case's dismissal. Unbearably undemocratic. Wait a minute. There really is only one democratic principle at play in a criminal trial. It is when the 12 jurors that were selected by the defense attorneys and the prosecutors alike, a jury of Donald Trump's peers, heard all of the evidence presented by the prosecution and the defense, heard the arguments of counsel as to why they should convict or acquit Donald Trump. And you know what they did in record time? Some might even say in a New York minute. They voted guilty 34 times over. Guilt beyond a reasonable doubt. That's democracy. That is respecting the vote of the people. In this instance, the people are the jurors. So no, it's not unbearably undemocratic. It's called accountability. Sport. That was all my editorial edition. The article continues. Trump is making various legal arguments for getting the case tossed out, including that its continued existence, even with sentencing pushed out past the next presidential term, would improperly interfere with his upcoming presidency. And here's some more nonsense from Trump's lawyers. Quote, it would be egregious and unlawful for this court to hold the prospect of a 2029 sentencing over President Trump's head while he continues his service to the country, Trump's legal team wrote in his motion. But Manhattan prosecutors said in the new filing that there are multiple options short of throwing out the jury's verdict that would address concerns about interfering with Trump's upcoming presidency. And friends, just to give you a flavor of the prosecutor's new court filing, here is a short passage from the opening salvo of Bragg's 82-page motion. This court should reject Trump's motion to immediately dismiss the indictment and vacate or throw out the jury's guilty verdict based on the outcome of the recent presidential election. There are no grounds for such relief now, prior to defendant's inauguration, because President-elect immunity does not exist. And even after the inauguration, defendant's temporary immunity as the sitting president will still not justify the extreme remedy of discarding the jury's unanimous guilty verdict and wiping out the already completed phases of this criminal proceeding. As defendant, Trump does not dispute the 34 felonies of which he stands convicted involve purely unofficial conduct, not any official presidential acts. At most, defendant should receive temporary accommodations during his presidency to prevent this case from meaningfully interfering with his official decision-making. But multiple accommodations, well short of dismissal and vacature, throwing the guilty verdicts out, would satisfy that objective, including a stay of proceedings during his term in office if judgment has not been entered before presidential immunity attaches. By contrast, defendants' requested relief would go well beyond what is necessary to protect the presidency and would subvert the compelling public interest in preserving the jury's unanimous verdict and upholding the rule of law. That kind of says it all. Respecting the jury's unanimous guilty verdicts and upholding the rule of law. Because, friends, without a system that values and respects and enforces the rule of law, we're done as a democracy. So it's good to see, it's great to see state attorneys general and state district attorneys, state prosecutors standing up for the rule of law rather than bending a knee to an aspiring dictator. Because justice matters. Points of light, friends. They're out there. Points of light. As always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.